What's up, guys? Brian Fell Law Group PLLC here with your Florida Law Weekly Case Update. I got 5 cases for you. Some of them are very, very interesting, especially to me as someone who posts online videos. So let's get right to it. The first one is Florida Bar versus Girley. This is not a family law case, but very, very interesting and important for anybody who posts things online. So in this case, this has to do with 2 attorneys that got disciplined by the Florida Bar. They got suspended for 30 days because of things that they posted online. So basically what happened was this was an employment discrimination case, and the Girley's clients, the Girleys are a father and a daughter, lawyers, and so they represented a client who had a discrimination case based on race and national origin, things like that. I think he was a doctor and he was suing a hospital. And so essentially they won at trial, and they won like $2.5 million at trial. And then essentially 3 or 4 or 5 days later after the trial court essentially set aside the jury verdict and ruled on a motion for directed verdict that it had reserved jurisdiction on during the trial, and basically overturned the entire verdict and had a directed verdict in favor of the defendants. So after that, the Girleys, they posted online. What they did was the daughter reposted a post of her brother that essentially accused the judge of being racist and having that there was racial bias in the court system, and that the reason why this got overturned was because the judge was white and the litigant was black, essentially things like that. And it had some bad comments about the judge, and the father lawyer did an interview, and that was posted online as well, where he also talked about the same type of things. Unfortunately, the judge actually got some death threats and had to have increased security at in his courthouse and at his home and things like that. So it seems like it was a big mess. But these 2 lawyers, they got suspended for this, and I think this is super important. Suspended for 30 days. It was upheld on appeal by the Florida Supreme Court. I think it's super important because you got to be very careful about what you post online. I mean, regardless of the intentions, who knows if these 2 lawyers had super good intentions and they were trying to, right the wrongs of social injustice and things like that. As a lawyer, you don't have a free right to freedom of speech. It's a little bit different. You got to always maintain the propriety of the judiciary, and you can't do things to impugn them and call them out individually and things like that. So you got to be very, very careful of things you post online as lawyers, for sure, and as parties as well. Next case is a family law case, Cohen versus Stubblefield. It's out of the 4th DCA. This has to do with contempt and attorney's fees. And so some litigants who practice civil law know that in order to get an attorney's fees award in Florida, you need to have expert testimony on the reasonableness of the attorney's fees, the amount that you're trying to get. In family law cases, you specifically do not need to do that. That's in Florida Statute 61.16. But what this judge thought, and what many people may think, is that 61.16 has to do with need and ability to pay. So perhaps the rule not requiring expert attorney's fees witnesses only applies if you're seeking fees under need and ability to pay. Whereas here, this was a contempt motion, and basically the litigant got fees for the MSA based on the enforcement clause, like a prevailing party clause under the MSA. So the trial judge, I think, was thinking, well, if it's just a contractual prevailing party attorney's fees clause, then maybe you need expert testimony to prove the reasonableness of the attorney's fees to be awarded. Well, the appellate court said, no, you don't, because Section 61.16 says that you don't need an expert for any proceeding under this chapter. So that's chapter 61. So not just need an ability to pay, but any proceeding under the chapter. And because this wasn't a proceeding under the chapter 61, you don't need an expert witness on attorney's fees. So basically, you don't need an expert witness on attorney's fees or anything, anytime you're trying to get fees in a family law case, I guess. I guess that would also include 57.105, other things like that. Next case is Wiendl versus Wiendl. This is out of the 2nd DCA. This one was one where the parties were pro se, and the husband, they kept filing motions against each other, blah, blah, back and forth, like many, many motions. And so what the trial court did was they got so mad that they said, okay, Mr. Former Husband, if you want to file any additional motions, you need to have an attorney do it. You can't do it yourself. And so but apparently he wasn't given any notice or opportunity to be heard before the court essentially sua sponte entered this order saying no more filings unless it's with an attorney. That was improper. He was at least entitled to notice and opportunity to be heard before having such a severe sanction imposed on him. Next case is Squires versus Squires. This is out of 5th DCA. And this one was interesting to me. So this is a modification attempt to modify a parenting plan. The statute, 6113, specifically states that in order to modify a parenting plan, and an action to modify a parenting plan, the court must make specific findings under the applicable factors of 6113. But apparently that does not apply if the petition to modify is denied. So that's what the 5th DCA held, is basically if the court is just denying your petition to modify, you don't need to have specific findings. Like basically you don't need to say why. You can just say denied. You don't really need to go through an analysis of why it's being denied, and you don't have to go through the analysis of the factors and things like that. I guess it's only if you're going to if the court is going to modify the parenting plan, then they do need to go through the factors. But if it's just a denial, then no, don't need to do the factors. Last case is Saladino versus Saladino. This was an interesting case, and it has to do with the need to pursue motions before a final judgment is entered. So basically what this was there was a standing order that was entered by the court during the underlying divorce proceedings that, among other things, basically said that the husband had to continue to maintain insurance for the parties, I guess. It includes car insurance. And so what happened was the wife got into an accident and she didn't have insurance. And so what she did was she filed a motion for contempt of that standing order during the underlying divorce proceedings. However, that apparently it wasn't heard for whatever reason. And then final judgment gets entered, and then she files an amended motion post-judgment trying to basically enforce that same standing order. Problem is, because it's post-judgment and she didn't pursue it before the judgment was entered, and because the judgment itself did not reserve jurisdiction to adjudicate that matter, she was out of luck. So if you really want something to be preserved, and you want to have a chance to litigate it after the final judgment is entered, you gotta at least either get it heard before the final judgment is entered, or at least get the final judgment to reserve jurisdiction to adjudicate it after the final judgment is entered, because otherwise you're going to be out of luck, just like this litigant was. All right, guys. Well, I hope you have a wonderful weekend, long weekend if you're taking off Friday, and I will see you guys next time. Take care. Bye.